SJC-11614, Commonwealth versus Alleyne.
Good morning, Mr. Wood.
Morning, Your Honor.
Okay, we are all ears.
May it please the Court, Chauncey Wood for the appellant Kyle Alleyne. In this case, defense counsel objected to or gave the trial judge notice of 3 different errors which he failed to address, he being the trial judge. Together, these 3 preserved errors clearly warrant reversal of the conviction. I will ambitiously try to cover all 3, at least briefly, in my 20 minutes. First, the prosecutor and defense attorney notified the judge on the 10th day of trial that 2 different jurors had been sleeping for much of the testimony.
Wait, sleeping or appear to be struggling to remain awake?
That's right, struggling to remain awake, and I submit that there is no significant difference between those 2.
Have you watched us recently?
Well, one of the cases was Banesh, and in fact, they resolved that as they were taking notes. So the eyes were open and they were taking notes. So I think that's.
But isn't there? I mean, we've got some jurors are late nights. Some have kids. I mean, a lot of folks are struggling to remain awake during a trial. If that is to be the standard for removing them, that would really change. Would that not change our case law? I know our case law says if they're asleep or if they're otherwise not listening, but struggling to remain awake is sufficient?
Right. So I think that this is not a change in the case law. I would cite McGee. In McGee, this court stated that if a judge receives information that a juror was asleep or otherwise inattentive, the judge must take further steps to determine the appropriate intervention.
Well, the juror in McGee was snoring, right?
Well, in fact, that's what one juror reported.
Right.
The judge, the prosecutor, and defense counsel all noted in McGee that they had not noticed this juror to be sleeping at all. So I think, and despite that, this court held that the report of the juror reporting snoring was reliable information requiring further investigation. I submit that in this case, we have a reliable report from the prosecutor and defense counsel. The prosecutor says that the 2 different jurors were, struggling to remain awake for the entire testimony. Here we were in the 10th day of trial, so for 8 or 9 days of testimony, this prosecutor is saying that this juror had been struggling to remain awake.
Wasn't it the case that the defense attorney said, yes, I've been told about juror number 12, but not juror number 3?
The first part is correct. The second part is not correct. He did not say, I have not been told about juror number 3. He said, I've been told about juror 12. But I don't think that that's any, that doesn't undermine. First of all, it's the prosecutor.
No, I understand that, but I don't, my only point is I don't think there was a sort of universal acknowledgement that juror number 3 was a real problem all the way through the trial.
That's true, and again, I would go back to the case of McGee. In McGee, neither the prosecutor nor the defense lawyer nor the judge noticed this juror to be sleeping, and this court reversed based on the failure to investigate a reliable report from a single juror. Here, we have, I think, more reliable information from the prosecutor about juror number 3.
With your argument is not reliability, it's the nature of the information that's being communicated to the judge.
Right. I think that when the prosecutor says struggling to remain awake, I think that leaves, and the prosecutor obviously thought this was a concern because the prosecutor brought this to the judge's attention. I think that quite clearly illustrates that the prosecutor was concerned that this was an issue that warranted investigation. If, in fact, the prosecutor thought it wasn't a problem, that this juror was merely tired and struggling from the burdens of life and just struggling to pay attention to a lengthy proceeding, the prosecutor, I submit, would not have brought that to the judge's attention.
Well, was there a second report to the judge about this particular juror?
There was that was day 10 that report was made. Day 12, juror 12, I believe, was dismissed because of a work conflict. That's right, juror 12. And the defense lawyer said this was, quote, at the time of being excused, quote, this was one of the jurors who we had noticed had been dozing off. So there's an inference, I think a reasonable inference there, that we I don't know if he's talking about we, the defense lawyers, or we, the defense lawyer and prosecutor, but one of the jurors who we had noticed had been dozing off. It's not clear. The implication is that the defense lawyer has noticed that more than one juror has been dozing off. And then the judge says, I recall that, and gives takes no other action. Now, I think that it's a possible inference from that, perhaps a reasonable inference, that the judge, in saying I recall that, it's not clear if the judge is saying I recall you raised this 2 days ago, or I recall this being an issue of these jurors sleeping. It's not clear. In any event, the judge did not investigate. And I submit that the crucial point here is where you've got a prosecutor, an officer of the court, raising this, illustrating they think he thinks it's important enough to bring to the judge's attention. There is a reasonable danger that the juror had missed some portion of the proceedings, and at the very least, this warranted further investigation. Now, the second point we want to raise is that defense counsel objected to 18 gruesome and duplicative autopsy photographs and 1 gruesome and irrelevant crime scene photograph. The trial judge allowed all of these to be introduced over objection and failed to give any contemporaneous cautionary instruction. And the last point we want to raise is that defense counsel's objection, the trial judge erroneously instructed the jury that Mr. Alleyne had exercised his right not to have his custodial interrogation recorded, undermining the instruction required by this court in Di Giambattista that jurors may consider a lack of a recording in evaluating the voluntariness of a defendant's statement.
Well, the judge instructed on that as well.
The judge
Said undercutting, but you're not saying the judge didn't instruct in accord
Sorry,
with
on the third issue, yes, Di Giambattista, that's right. The judge gave the standard Di Giambattista instruction, and then what we're really saying is that the judge gave an addition. Our complaint is with the additional instruction, not that he did not give the
And it
instruction.
seems clear that he gave that instructions to ensure that the jurors didn't draw any negative inferences from the defendant's refusal to be tape recorded.
I think that was the judge's thinking. That is, I think the judge explicitly said that. I think that's absolutely an accurate characterization of what the judge was thinking. I think the problem...
It was open to trial counsel, correct? I know that you're arguing that it should be required, but at the time, it was certainly open to trial counsel if he was really concerned about the added instruction about exercise his right not to do this, to just not have the Di Giambattista instruction, because it is on request, right?
I think that was, yes, it was open to defense counsel, I would say, to throw out the baby with the bathwater. Yes, I think that the Di Giambattista instruction is crucial. I think it would be unwise for defense counsel, well, crucial to the defense in this situation. The defense obviously wants the standard Di Giambattista instruction.
Do you think it would have been fair in this trial, with the law being as it is, it would have been fair to have the Di Giambattista instruction with no comment about why it wasn't recorded, when in fact we know that he signed something that said he didn't want to have it recorded? That would be fair?
I think that illustrates the problem, which is precisely why I'm advocating what I'm advocating. I think, Your Honor, put your finger on it. I think it is deeply problematic. I think that the point, this is why we've presented the argument, I think that, in fact, this illustrates that Di Giambattista has spawned a problematic custodial interrogation practice among police. I think that it's true that what was presented to this court, on the record presented to the court, we all agree that there's some sense of unfairness about not allowing the police to explain why this wasn't recorded. I agree with that, and that's your point, and I think that's fair. But I think it's necessary to step back and say, how did we get to this point? And I submit that we got to this point not just because of the practice of this one police department, but the practices of a whole bunch of police departments, as documented well by CPCS in its amicus brief, in a post-Di Giambattista world. Police departments, and I think this might, most favorably to police departments, it might be stemming from a misguided understanding of the wiretap statute. They believe they need to obtain the defendant's consent before they record the interrogation. And so they say to the defendant, we were supposed to record this. Can we have your consent to record it? And we submit that therein lies the problem, that when police departments engage in this practice they undermine the Di Giambattista
They should
regime.
just be saying, this is recorded. Our conversation is being recorded, period, the end. That's
Yes, and an example of this is in the Pittsfield Police Department. Not everybody's doing this. The Pittsfield Police Department does exactly what we think should be done. They simply say this is going to be recorded, period. I would also point to the District of Columbia. That's also cited in, I think,
Yeah, it
at
is
least
cited somewhere.
somewhere.
yes.
At least it's certainly cited in the CPCS brief. I think I cite it, but I'm not sure. But it's definitely in the CPCS amicus brief. But they say there quite clearly, you shall simply do that, and you may not, the police, may not invite the defendant to not have it recorded, to alert the defendant to the choice of not having it recorded. So I think that ultimately what this court's, and the reason we advocate this is we submit that this will further the objectives of Di Giambattista. The objectives of Di Giambattista are, I think, very sound, to encourage as many recordings of custodial interrogations as possible for all sorts of reasons, and I can list all of them from Di Giambattista: deterrent to police misconduct, reduce the number and length of contested motions to suppress, allow for more accurate resolution of issues raised in the motions to suppress, and at trial on the merits, provide the fact finder a complete version of precisely what the defendant did or did not say, and any statements or confessions. So there's lots of...
But the police are correct that you do need consent for them to, I mean, what you're saying is that one can imply consent when you say this is going to be recorded, and then if you speak, you are implicitly are consenting to the recording, much as a telephone call may say, you know, this call is recorded, and if you say anything, then you effectively are viewed as consenting to it.
Well, I respectfully disagree. Maybe our disagreement is more minor than it first appears. I'm not sure. My understanding is that Commonwealth v. Morganti, this court made very clear that the wiretap statute does not require consent for a recording. It merely requires notification. The wiretap statute is designed to prevent secret recordings, not non-consensual recordings. So in other words, the police can say, we're recording this, and we don't care. Your choice is to not speak.
Right,
But
right.
so I think that's the law. So I think that there is no requirement under the law, or by implication, that the police get the defendant to consent to the process. The defendant clearly has the choice not to speak, and that's already clarified in the Miranda warning. So,
Because isn't it, I can hear the next case coming, though. In the next case, if we were to adopt your proposal, the next case would come out of Pittsfield, for example, and where the defendant said, well, if it's being recorded, I don't want to talk. And then they turn everything off, and the defendant doesn't get to make a statement. Or he does make a statement, and he complains about it being recorded, saying, I didn't want this recorded. What do we do in a situation where the defendant says, I don't want it recorded, but nevertheless continues to make a statement? Does the Commonwealth entitled under those circumstances to show the video of the statement to the jury?
okay, so I think those are two separate hypotheticals, just to make sure that I understand.
Yeah.
The first hypothetical, the defendant says, I don't want to be recorded,
Yeah.
and the police honor
Record
that.
it. No, they record it.
They continue to record over the defendant's objection.
Yeah.
And the defendant speaks.
Yeah.
Okay, it's not clear to me in that situation, I'm not trying to quibble, why the defendant would continue speaking if he's just said, I'm not going to talk if you record it. Well, we're going to keep recording
Because
it.
he wants to make a statement.
Okay. So under Morganti, I think there's nothing wrong with that. If the police have recorded it, and I think it's clear to the defendant he doesn't have to speak because a Miranda warning has been given. And if the defendant, in any event, speaks, and the police are clear that we are recording this, there's no violation of the wiretap statute. I don't think there's any issue.
So the defendant's twitching away during the recording, putting out, and he casts a terrible visual image that is, at least arguably, from the defendant's perspective, prejudicial to the statement that he's making.
Defendants, much to my chagrin, always do things that they shouldn't do in police stations. This is not in any event, this is not in any way different than the old Miranda cases. You have a right not to say anything. And then you talk. Why are you talking? They just told you you don't have to talk. I think it's the same. Now they're recording you. You don't have to do anything. Go back to your cell. There's all sorts of stupid things defendants do that we can't protect them from. But I don't think there's any constitutional or other legal problem with that hypothetical. I think there was you had a second hypothetical, which I thought was different. If the defendant chooses not to speak, I think there's nothing more to put.
So the individual, maybe he's not the defendant at that point in time, but he's
Suspect.
Suspect, it's custodial.
Right.
Says, look, in my neighborhood, you don't put anything on tape, man.
Right.
I don't want this played on my block tomorrow.
Right.
I'll tell you what's going on, but no recording.
Right. So I'm going to identify the third party. That's what you're getting at, I think. I didn't do it, but I'll tell you who did it. But I won't tell you on tape because I don't want to be a rat. That's the idea?
Right.
Right.
Well, we have
So
a case like that today. So
I addressed this specifically in my reply brief, and I actually think that the cost there is virtually zero, and it requires a little bit of thinking. But specifically, first of all, if you play it through, there's two options there with that suspect. That suspect is either going to cooperate at trial or not cooperate at trial of the third party. If they cooperate at trial, there's nothing lost for refusing to record this interrogation because they will say what they said. Alternatively, they could be given immunity and be forced to say what they said, so nothing is lost. Alternatively, they say, no, I'm not testifying, and for whatever reason, they're not given immunity. Under that statement cannot be used. That statement could not be used against the third party in any event because of Bruton versus United States, because that's inculpating a third party, and if the defendant is unavailable for
But
cross-examination.
the result of Justice Cordy's hypo will be that no statement is given. I'm not going to talk to you if it's going to be recorded, because I worry that tape recording will get on the street. So
Right.
I'm going to say nothing when I otherwise would tell you who did the shooting.
I actually got carried away by my own rhetoric. I actually, I think the solution is.
first time ever.
I know, right? But I keep you awake at least.
You do.
I think that, in fact, in that the answer is, if a defendant says, "I don't want to talk on tape. I want to rap because I want to tell you what happened, but I don't want to talk on tape." I accept that CPCS solution. This is different than my briefing, but I accept the CPCS solution, which is as long as the idea for not being recorded comes from the defendant and not from the police, and as long as that statement is recorded by the police, so we have a clear record on voluntariness, then I would submit that unrecorded statement is permissible. And it's important to take a step back and recognize we're not talking here about preventing the police from having unrecorded conversations. We're simply talking about the situations in which unrecorded conversations will not be admissible, the substance of those conversations will not be admissible in court. So, of course, for investigative purposes, this is irrelevant. The police can talk to whoever they want to talk to. For admissibility purposes, I would say that hypothetical under the CPCS solution, which I advocate now, would still be, that would even be admissible.
Could I ask you about the photos? The judge apparently made a finding that all of the photos related to some probative issue in the case. Was there a number or of photos that the judge should have stuck with? Or are you saying that he shouldn't have admitted any of them because they were all so awful? What should he have done here?
I think that the judge should have, I think, first of all, the judge effectively abdicated his obligation to exercise his discretion.
Well, how many photos did the judge look at?
There were
300?
There were 44 admitted altogether, the ones that the defense counsel, the crime scene and autopsy. Defense counsel specifically objected to one crime scene photo and 18 autopsy photos. I can't remember right now whether there were other autopsy photos that defense counsel didn't object to, but I know clearly defense counsel objected to 18 autopsy photos and one crime scene photo. Those 19 photos are the 19 photos we're complaining about here. Nobody's complaining about the judge's actions with regard to the remaining crime scene or autopsy photos, if there were any. So I submit that...
But you're saying that the judge didn't exercise discretion. He abdicated.
That's with regard to those 19. I'm saying...
Well, but the judge exercised discretion in excluding about 180 others, didn't he?
I don't want to misstate the record. I'm not sure. My
Commonwealth argues that there was more than, I think that Justice Spina is correct, it's somewhere in 300.
Almost 300 photographs.
I remember the prosecutor, the Commonwealth drafting, making that argument. The only thing that I'm not clear about is whether the prosecutor actually sought to introduce them or whether the prosecutor was self-selecting. It's not clear to me. I'm not arguing the point. I don't remember whether the judge actually excluded some. There were a lot more. There were like 300 photographs. The question was, did the judge actually exclude any of them? I'm not sure about that. But in any event, if the judge did exclude them, then I agree with you. The judge did certainly exercise discretion to that extent. But the answer to Justice Hines' question, I submit, of the 19 photographs, I submit that the one photograph of the victim's body laying on top of the sleeping bag was completely irrelevant and highly prejudicial and should have been excluded. That's one. And with regard to the other 18, the judge should have, at the very least, excluded the duplicative photographs. So there were 7 different wounds that were photographed close up and far away, and the mid-range. The mid-range shots illustrated lots of decomposition, rotting flesh, and in any event didn't add anything. So the judge should have, at the very least, excluded the 7 duplicative photographs there, and so you would have had 11 photographs instead of 18, and you would have also dramatically reduced the amount of prejudicial decomposition, rotting flesh, and other irrelevant, highly prejudicial evidence.
Thank you.
Thank you.
Ms. Sylvia, good morning.
Good morning, Your Honor. May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney from Middlesex, appearing on behalf of the Commonwealth in this case. Your Honors, as my brother noted, there are actually 2 issues with regards to DGM Batista here. One is the judge's instruction, and that was objected to below. And the second is something that's raised for the first time on appeal, and that's the argument regarding overruling DGM Batista and creating an exclusionary rule and excluding otherwise relevant admissible evidence from the jury based on the lack of a recording. With regards to the judge's instruction here, he gave the full correct DGM Batista instruction, both at the time of the testimony and during his closing instructions to the jury. And then he added that the defendant had a right to refuse the recording. He did not actually go on to say, at least on the final instructions, and I'd have to check with regards to during the testimony, he did not actually go on to say you can consider his refusal as going towards the voluntariness, as going towards why this statement was not recorded. He actually did not add that. So I would suggest that this instruction that the judge gave here was actually more favorable than the model instruction and the instruction in Rousseau that this court approved of, or well, that this court upheld. And I'd also point out that with regards to whether or not the defendant had a right to refuse, that's something that, again, that was referred to in the Rousseau case. This court's acknowledged that a defendant has a legitimate choice in the matter. It was acknowledged in DGM Batista, and it was acknowledged again in Rousseau. I think, frankly, until my brother raised it, it's something that was not in any great doubt before this court, that a defendant has a legitimate choice, a decision to make as to whether to be recorded.
As a matter of policy, why shouldn't we do what Mr. Wood, I mean, doesn't it make sense for all the reasons that DGM Batista itself articulates?
Well, I think DGM Batista itself makes perfect sense. It expresses a preference for recording, and I think that the police have been complying with this court's preference in that regard. I think I do think it's good policy, but what I don't think is good policy is to exclude relevant, probative, admissible evidence from the jury's consideration, to create an exclusionary rule when it would have no deterrent effect. The police were already doing what this court has expressed a preference for.
I sort of see 2 questions. One is what happens if you fail to comply. But I thought that the thrust of the argument being made is that it would be better for all concerned actually to have more recordings rather than less.
I don't think there's any question that that would be better for everybody concerned, in particular, frankly, for the Commonwealth. That's why this argument, to me, frankly, is very strange, suggesting, because it inevitably would inure to the benefit of the Commonwealth here. But I think that's...
I can tell you that's not always the case. It actually does help the defendant also.
Well, sometimes you mean when the statements are recorded?
Yes.
Yeah, and it does sometimes, and that's part of the problem with saying that, sometimes, I think the essential problem here is I think what we have is lawyers trying to impose their judgment on defendants, saying essentially, we know better than you do. This should always be recorded. You shouldn't be speaking to police. And I think that's what this is really about. Exactly what my brother said earlier, which is defendants do all kinds of crazy things I would never advise them to do, like talking to the police. And I think that that's what this is about. I think it's about a belief on the part of defense attorneys that if statements are forced to be recorded, the defendants will not speak to the police. And frankly, I think, first of all, it's questionable whether that's true. And secondly, it's very questionable as to whether that's good policy, whether what we really want to do is prevent people from speaking with the police if they choose to do so voluntarily. And again, I just would point out that what the exclusionary rule should do is it should advance a deterrent effect, and I just don't think there's anything to deter here because the police have been.
I take this as not, I just didn't think that was the thrust at all, was the exclusionary rule. I mean, about this statement, because it wasn't made, it seems to me, frankly, even if we were to do what Mr. Wood asked for, given that it is not a constitutional requirement, I have trouble believing that the court would say it would apply in this case necessarily. But so I'm looking at this as a going forward matter.
Right, and I understand the benefits of recording. I really do. And I think if the court just wanted to restate again, we have a strong preference for this. This is what you should be doing as policy matter. It's a good idea. That's one thing. But it's different to say we're going to exclude evidence. I think that especially in the case in front of us, as you said, there's just no deterrent effect to be served whatsoever by excluding relevant evidence from the jury's consideration.
So what about the notion that if someone does not want to be interviewed on tape, that the police should insist that be on tape? That your refusal, if you're going to refuse, you must do that on tape.
I mean, I don't think that, again, as a policy matter, that's a bad idea. If the court wanted to express a preference for that, again, my problem with this is the concept of removing evidence from the jury's consideration. Okay. I don't disagree that, frankly, it would probably protect the Commonwealth. I do disagree strongly that it should create an exclusionary rule, or that in particular in this case that it should have any impact on this conviction. I also just wanted to...
Now, we may have used the language of a right to refuse, but I don't recall us ever having a matter where we have considered it and said that that is a right.
Right.
So I suggest that you're not saying that we should declare it to be a right, because if that's the case, then Pittsfield, arguably, if it's doing what it's doing, could arguably be in violation of granting a defendant a right to refuse.
Right, and sorry, I don't mean to. I think that's the problem with the word right. Like what I just said is right, because right, it doesn't necessarily mean, we're all lawyers in this room, so we're all thinking about rights in terms of constitutional rights and waiver and voluntariness. I don't think that's actually what the judge intended to convey here, and I don't think it is what he conveyed to the jury. I think he meant a right in the colloquial sense, like his decision, his choice, his prerogative to decline to be recorded.
Right. Well, in this case, the police, regardless of whether there is a constitutional right or a statutory right or a common law right, the police gave the individual that choice.
Exactly right, exactly correct. If you look at, excuse me, if you look at the record appendix at page 29, I have a hard time seeing what the defendant's issue is with this, or the amicus issue is with this recording form. It says, it is the policy of this department.
Which record appendix are you talking about?
It's the defendant's record appendix at page 29. It says, it is the policy of this department to record all interviews so that there is a record of our discussion. Do we have your permission to tape record our discussion? And that says, yes, I agree. No, I do not want our discussion recorded. And so I'd suggest that this actually is very favorable to defendants. It's pretty neutral language. It's saying it's our policy. It's not saying you have the right to go ahead and refuse if you don't want to be recorded. It's giving defendants the option. Do you want to be recorded or not? It's our policy. And in fact, it also goes on to say the reason that the recording might be beneficial, so there's a record of our conversation. And it's also right below the Miranda advisements. So I think it's quite unlikely that a defendant would, I think that's actually a good reminder to defendants to have it on the same page. I don't think it's required, but I think in this case, it's quite a good reminder that you also have a right to an attorney and you have a right to remain silent if you don't want to speak at all. So I have a hard time seeing how the defendant in this case or in any case with a similar form could possibly be confused about what his rights are or are not. And in particular, I think it's very notable in this case that the defendant, in fact, invoked his right or his prerogative to be recorded during the first interview in Texas. So he clearly, if this is a ploy by the police or a tactic by the police to actually get people not to be recorded, it's not working particularly well because you have a defendant that decided to be recorded the first time around and then the second time made a different choice and decided not to be recorded when he spoke to the police the second time. So I do think, as Justice Botsford had pointed out, that this really should be a singularly unlikely case upon which to, first of all, reverse this conviction on these grounds, and secondly, to overrule D.J. Batista and create an exclusionary rule based on unrecorded interrogations.
Turning to another issue, how many stab wounds were there?
There were 13, Your Honor.
13 stab wounds, and the defendant was convicted of murder?
By extreme atrocity or cruelty, Your Honor.
Extreme atrocity and cruelty, okay. And the photos that were put into evidence were photos of those stab wounds?
That's correct, Your Honor. Every one of the photos was of one of the stab wounds, with the exception, there were 18, I believe there were 18 of the autopsy photographs put in. Every one of those photos depicted one of the wounds, with the exception of one photo that had 3 of the wounds that were visible within that one photo. The photos that were duplicative, because you'll notice there were 13 stab wounds, but 18 photos, were close-ups of the wounds, and I suggest that was necessary because of the fact that she was stabbed so many times.
Okay, so she stabbed so many times. Why do you need close-up and far away? I mean, that does...
I think that it's difficult, frankly, because of the level of decomposition, to see, when it's a little bit further away, to see the depth and nature of the wound.
Okay, so leave out the further away ones. I mean,
I think then the problem is that you can't see where they're oriented on the body, and I think that's extremely relevant to extreme atrocity or cruelty. So even if it could have been done in a different way, I do think this is a discretionary call on the part of the judge, and he acted within his discretion. He did exclude the 3 additional photos separate of, I think their names J, K, and L maybe. He did allow only one photo of those 3 to go in, and he noted at one point that, these are really disturbing photos, and I certainly don't dispute that. They are. They're very upsetting to look at, especially for a layperson, I'm sure, but...
Was part of the reasoning of the Commonwealth in arguing that these decomposition photos were important, the fact that it appears that the defendant had, there were many, I don't know the number of days, but a good number of days where the body was in the house with him and the child? I mean, was that part of the point?
So I think that's... Oh, Your Honor, I'm sorry. I didn't mean
well, I can see that, but of course, extreme atrocity or cruelty goes to the actual killing, not what happens afterwards.
Right, and I don't disagree with that. I don't think, so first of all, I think the reason that the photos went on in with the decomposition depicted is because, as the judge said, there was no other way to reasonably do it. Her body was significantly decomposed. The Commonwealth did leave out the photos that showed areas of the body that were more decomposed and didn't put in an overall photo of the body itself that showed the very significant decomposition throughout. And so I don't see how it reasonably could have been different, I suppose. I did argue in my brief that I thought that it was relevant to time of death because, at a certain point, the defendant was, he was sort of claiming, I saw her when she was alive. I don't know if I left on Friday or Saturday or when it was. And so it made it clear it was quite a bit before they discovered the body and helped to establish the time of death. But realistically, I think that the reason that the prosecutor put them in, and I think the reason that the judge allowed them in, was for extreme atrocity or cruelty.
And in answer to the question, maybe you already did answer this, but of the 300 or so, were those all sought to be admitted, or was it a kind of joint effort to figure out what was going to go in?
Yeah, the prosecutor didn't seek to admit all 300 of them. He sort of had selected a group of them and presented them to the judge, and I don't know if there was any back and forth between him and defense counsel or not, but the judge had sort of flipped through them.
They were all kind of looking at it together.
Yeah, exactly. I think that's correct, Your Honor.
Now, I know the judge, during jury selection, spoke to the jury about the likelihood of there being some gruesome photographs, but was there no instruction given when they came in by the judge?
Your Honor, unfortunately, there was not. I think that I think the judge believed mistakenly he had given that instruction. You see in the closing instructions that he says, as I mentioned before, obviously, would it be better if he'd given that instruction? Of course it would have been.
In the closing instructions?
Yes, yes, Your Honor.
So it was part of the jury impanelment and in the closing,
In
but
closing.
not at the time?
Exactly, Your Honor. And I don't think that's required. As I said, I think it would be helpful. Certainly, it'd make my job easier today. But I don't think it's required, and I don't think this court has ever said it's required. And again, I do think that although the photos are quite disturbing, that when you stab somebody 13 times and leave them to rot for 5 days, that's unfortunately sort of the result when you go to trial. That I don't see, as the judge pointed out, how reasonably this could have been done particularly differently. Turning to the issue of the so-called sleeping juror, or the juror that was struggling to remain awake, I'd suggest that the judge acted, again, within his discretion in not holding a voir dire of the juror that one of the lawyers said was struggling to remain awake. First of all, nobody requested a voir dire, which one would expect of two such diligent attorneys, one of whom saw fit to bring it to the judge's attention. I would suggest out of an abundance of caution,
But
because
we've
he's trying
said
to do
that
the
the
right
judge
thing.
has a duty to act on his own, though. Haven't we said that?
Yep, that's absolutely correct, Your Honor. I think, though, that it goes to, what I mentioned, I think, goes to the nature of the report more than it does whether or not, the judge absolutely has a duty to act on his own if there's credible information. I think it goes to sort of the reliability of the information, the type of the information, that if this was a juror that truly was remiss in his duties and, was falling asleep and drooling and snoring and so forth, I think that it's fair to infer that an attorney that was diligent enough to bring it to the judge's attention would have said something beyond okay, very good, thanks, Judge, that's fair enough. I think it's fair to infer that it's likely that attorney would have pressed a bit further if this truly were the issue it's being made out to be on appeal. And I also just would point out that the standard that I think that my brother is suggesting should be applied to jurors with regards to anybody that's being inattentive in any way. I think that would be an impossible standard to apply. If what the standard was everybody has to be 100% interested at all times, and we're judging, whether or not people are being completely attentive. I think that there are quite a few people probably in the courtroom right now that are not being particularly attentive, and that maybe are struggling to remain awake.
Watch how far in the courtroom you go with that.
Well, I mean, but that is the language of McGee. I mean, McGee makes reference to that. But I mean, I can imagine somebody who is simply not, who is awake, but is not paying any
you're playing on
attention
your
to what
phone
is
for-
going on, or something
Yeah.
to that effect. So, I mean, I think I wouldn't necessarily want to say that being inattentive is irrelevant.
It's certainly not desirable, and I think that there are situations where that inattention could be pretty clearly demonstrated. If you're playing Candy Crush on your cell phone through 10 days of testimony, and the judge does nothing about it, I think that's probably the type of inattention that that you envisioned in McGee. Whereas struggling to remain awake, or not being particularly interested, or being sort of tired, or staring off into space, I think that's a pretty impossible standard. I think we'd spend all day doing voir dires, possibly of attorneys as well as jurors, if that were the standard. So I just suggest that can't be the standard here, and it's not what the court should apply in this case. And if there are no further questions from the panel, I'd rest in my brief, and I'd ask you to affirm the defendant's conviction for the murder of Heather Dvorsnik Alleyne.
All right, thank you.
Thank you.